This is the Secrets of Attorney Marketing podcast from Speakeasy Marketing. Discover how to enhance your reputation as an attorney and outmarket your competitors. Make sure you subscribe to the podcast and post a review.
Hello, this is Richard Jacobs with the Secrets of Attorney Marketing podcast.
Yeah, Kevin, tell me about a recent case that you worked on where the outcome was maybe really uncertain, or there was a really problematic type case, but you prevailed, and what you think caused you to prevail. So any good stories you have?
Well, I had this case recently where the client was at a restaurant earlier in the evening, and the bartender called the police because they thought that she was intoxicated and was about to drive her car. Now, the client was adamant about the fact that she really wasn't intoxicated and actually didn't have any intention of driving her vehicle. She was also pretty aggravated that the police got called out to the scene. However, she arranged to have a friend take her back to another friend's home where she would stay for a little while, and then she decided to drive home. So what happened with the initial call, the police came out to this restaurant. They did a very cursory investigation into the situation and thought that she was intoxicated, but didn't do anything about it. They left. They were satisfied that she was going to get a ride home. Her friend did take her vehicle back to another friend's home, and they were there for an hour and a half or so. All three of her friends who were at this house believed that she was completely sober. She thought she was sober. She got back into the vehicle, decided to drive home, and encountered the same police officer on the roadway that came into contact with her back at the restaurant. So
just backing up for a quick second, what happened at the restaurant when she first encountered the police? What did they say?
They, at trial, and I'm kind of cutting to the end here, but at trial they said that they believed she was intoxicated, but they didn't do anything to make that determination as one would normally do in a DWI investigation. For instance, they didn't do any field sobriety tests. The conversations that they had with her were very brief. And as I said, they were satisfied that she was not going to be driving home, especially after her friend showed up and offered to drive her vehicle to their mutual friend's house. So they did that. They got to the mutual friend's home. She was there for some time. She got back on the road, and the guy that drove her to the mutual friend's home was following her home in his own vehicle. And he thought she was driving fine. She wasn't speeding. She wasn't driving erratically. She made a turn off the main road, and they departed at that juncture. And as she made that turn, the officer who had seen her at the restaurant started to follow her. Now, he claimed in his report that he didn't realize that it was her that it was the same person he encountered at the restaurant, but she had made the turn at a high rate of speed. Her friend, who had been driving behind her, said that she made that turn just fine, and it wasn't at a high rate of speed. So the officer apparently had to do a U-turn, started to follow my client, and had lost her. She was down the road. It was a curvy road where he could not see her at times, and that was evident from the dash camera. Mm-hmm. So eventually he caught up to my client's vehicle. And at the time that he caught up to her vehicle, it was a dark roadway. He had been driving pretty quickly to catch up to her. He was very close to her vehicle, and her vehicle very briefly drifted over the center line and then back to her lane. So the officer used that as a reason to stop her car, which he initiated a motor vehicle stop. She pulls over. She pulls over just fine.
Yeah, quick question here. How often, in your experience, do police, when they follow someone, they essentially cause the person to be so nervous that they won't drive perfectly, and then they're like, I gotcha. Do you think that's what's going on here, and how often does that happen?
I think it happens often on a dark roadway where there are very few cars traveling on that roadway, or no other vehicles but the client's vehicle and the police officer's vehicle. So, I mean, picture this. You're driving down a rural road or like a semi-rural road. There's not much lighting on it. And out of nowhere, this vehicle is driving up at a fast pace from behind. You got the headlights in your rearview mirror, and of course it's going to be distracting, and it's going to take your eyes off the road for a few seconds at least. And the cautious driver, no doubt, is going to be concerned that this person behind may be tailgating, may be intoxicated, may be putting the driver in danger. So yeah, that's going to, I think, oftentimes be a very distracting factor. I've had many clients tell me that was an issue which caused the driver to fail to maintain his or her lane. And it's pretty evident from the dash camera that was, in fact, what happened with these clients' cases. So getting back to this case, my client pulls over. She parks her car fine. The officer goes to the driver's side window. He recognizes her. He says he wants her to get out of the vehicle to see if she's intoxicated. She adamantly denies being intoxicated. And in fact, she does very well on the field sobriety test, which fortunately were captured on the dash camera.
They were or they weren't?
They were captured on the dash camera.
Okay.
So,
and just for people that don't know, so what are the standard field sobriety tests in layman's terms? They pull you out of the car, they shine the light in your eyes and move it back and forth. They ask you to follow it. Like, what are, again, in plain speak, what are the major field sobriety tests that are done typically?
In New Jersey, the officers typically use standardized field sobriety tests, which are the heel-to-toe touch test, the one-leg stand test, and the horizontal gaze nystagmus test, which is an eye test, essentially. Those three tests are standardized according to the National Highway Traffic Safety Administration. In other words, the officer has to administer those tests according to certain guidelines and grade them according to certain guidelines. What makes them standardized is that every officer in the state of New Jersey who's trained to do the standardized tests should be administering those tests in the exact same way and grading those testings in the exact same way. And any officer throughout the entire country who gets standardized field sobriety test training should be doing the testing exactly the same. So that's what makes them standardized. In New Jersey, most officers administer the three standardized tests. Some will add an alphabet recitation where they have somebody recite the alphabet without singing, starting from a random letter and ending at a random letter in the alphabet. That's not a standardized test. There's no so-called scientific reliability when administering that test or grading the test. Same with counting backwards and even like a finger-to-nose touch test. Those three tests that I just mentioned, the non-standardized tests, realistically what they're supposed to be used for is these officers should have a driver do the tests while the driver's inside the vehicle and then make a determination based on those tests whether to get the driver out to do the more so-called more reliable standardized tests.
Just for people to understand, so the horizontal gaze and the nystagmus, again, that's where they'll take a pen and they'll say, follow this pen with your eyes, and they'll move it left and right in your line of vision. And I guess they're looking for your eyes to make jerking motions as you look to the left and the right.
Yeah, that's exactly right. So the officer's trained to use a stimulus, which that's the technical term. It could be your fingertip, could be a pen tip, could be something with a little light on the end of the tip. And yes, that the person's supposed to follow the object for what's called like a smooth pursuit, sustained nystagmus, distinct and sustained nystagmus at what's called maximum deviation. Essentially, your eye can go no further left or right. And then they look for the onset of nystagmus prior to 45-degree angle from essentially where your nose is to the left or the right. Anyway, so that test, the horizontal gaze nystagmus test in New Jersey, is not allowed to be used as proof in a trial to show somebody may be intoxicated. The most it can be used for is to determine if there's probable cause to arrest somebody, take them back to the station, and have them breathe into the breath test machine. Oh,
so they do it at the station in New Jersey. They don't do it in the field.
Right. They don't.
Okay.
Yeah, the device that they use in New Jersey is the Alcatest 7110, which is now being phased out to the Alcatest 9510.
Okay.
So getting back to the situation with my client, as I said, she was doing very well in the field sobriety tests. And by the way, the officer failed to even administer those tests properly. I suggested to my client to bring in an expert witness who could comment on the poor administration of the field sobriety tests. The reason I use expert witnesses in my cases is because in New Jersey, the case law that the judges go by really allow for the judges to place a lot of weight on how somebody performed a field sobriety test. So what I suggest to my clients is that they bring in a former New Jersey state trooper who was in charge of training thousands of police officers how to do the field sobriety tests. He truly is an expert because not only did he receive training at the student level, the instructor level, he did act as a higher level coordinator within the New Jersey State Police with regard to DUI detection training. And then he actually ran the entire program for the state of New Jersey for a period of time. So he knows the scientific literature, he knows the case law, he's administered it himself to suspected drunk drivers, he's trained plenty of officers on how to do the testing, and he's testified throughout the state of New Jersey concerning the field sobriety testing. So you get him involved in the case, and then he can write a report criticizing what the officer did concerning the field sobriety testing. And not only did we want him for that purpose, but we wanted him to talk about the breath testing. Because even if I convinced the prosecutor that the field sobriety testing was done improperly, I still have to get the prosecutor to believe that the breath testing wasn't done right. So we got to the breath testing issues. One of them had to do with failure to watch my client during a 20-minute observation protocol period, which essentially means that the officer has to make sure that the person who's about to be breath tested doesn't put anything in her mouth, doesn't regurgitate, doesn't vomit. And as long as those few things are done for this 20-minute observation period, then the breath testing can proceed. But if something is inserted in the mouth and if there is burping or regurgitation of some kind, then they have to start the 20 minutes over again. The officer does have an obligation as well to check the person's mouth before starting the breath testing observation period. So I was able to determine that there was an issue with the 20-minute observation period. There was also an issue with the documentation that was provided for the machine. There's what's called a certificate of analysis for this simulator solution that's used in the breath testing procedure. That's a very technical aspect of it, but what I could determine was that the official certification paperwork really was not done properly. There was a lack of proper notarization for it, and it's a more technical issue, but that was something that I decided I needed to file a motion to challenge, and if I could convince the judge that the certification of analysis or certificate of analysis was not properly put together, then the argument was that the results shouldn't be deemed reliable.
So how did this, it sounds like you're able to stack multiple problems. Like, I guess, I'm sure you did. You could bring up that the officer had the chance to test her in the bar environment and failed to do it. Then he followed her and essentially could have caused her to go over the line. So the probable cause for the stop was kind of self-induced by the officer in a way. Then he failed to do the testing right at two different spots, the breath test plus the field sobriety. Then there was a certificate problem. So was this building up as a preponderance of errors, a comedy of errors that helped get the client off, or did that not factor in?
Well, that is the goal, because it's easy for a prosecutor to shrug off one or two attacks on the state's case, but once you start building up the defenses, you're building up pressure on the state's case. And so you hope that the prosecutor will realize it's going to be a real battle. And you also hope that the prosecutor is going to really take a close look at the case and figure out, if he can or she can really prove guilt beyond a reasonable doubt at the trial. You want the prosecutor also to think about how good is my witness going to be. Does this prosecutor know the police officer who did the investigation? And if so, has this prosecutor ever had this officer testify at trial? Well, in this case, we had to go back to court 5-6 times, I believe. I really had to fight the entire way for discovery. I had to file motions to obtain discovery. And then over time, it took, can't quite recall how long it took. Over a year through going back and forth to court. We eventually came to the point where I was able to start negotiations, because I do not like to negotiate with the prosecutor until I actually have everything that I feel is part of the defense. I don't want to piecemeal it. Mm-hmm. So we started negotiations, and the prosecutor was unpersuaded. He just didn't want to budge. So I talked to my client about it. She was adamant that she was not intoxicated. She wanted to go to trial. This was the first time she's ever been charged with some type of offense of this nature. So not only did she feel that she was not guilty, but she was embarrassed by the whole situation. And I don't think she really wanted to live with the opprobrium one gets from having a DWI on your record. So she wanted to fight.
Did she have a high BAC or any significant BAC?
It wasn't significant, but again, there were factors involved here that certainly called into question the breath test result. When you're dealing with a prosecutor, I think a lot of times they look at the breath test result and they assume that it's correct. You'll give them defenses, and they'll look at your defenses as so-called technical defenses. But in their minds, they still think, well, this is how truly intoxicated the person was. I, as a defense attorney, don't look at it that way. I look at it as, well, you have to prove that the breath test result is an accurate one. And if I'm coming up with a lot of reasons for why it's not accurate, then you can't assume that the person's intoxicated. You can't assume that breath test result is accurate. So, right. It's different points of view. That's why I'm a defense attorney, and that's why the folks on the other side are prosecutors. So I understand where they're coming from, but it's my job to try to help them see it my way.
Well, another question here is, you said you went to court 5-6 plus times over a year. How common is it that you've seen defense attorneys will go to that length? Or is that even, do you consider that a lot of effort? Do you consider that an extreme type of thing? Or is that just standard in terms of defense?
It's standard in terms of my defense. I assume the case is going to take that long and I'm going to have to go to court that many times. The cases don't always go that way. A majority of them get worked out without having to go to trial, which is a good thing, because I don't know if I'd have the time for every single case if they all lasted a year and went to court 6-7 times, but they don't. It's just, I know that a few of them may go the distance in that regard. And if they all do, of course, I'm going to give them every single case my best effort and the absolute attention that it needs, but they just don't generally all go that way. But as I said, I anticipate they'll go that way. So that's my mindset when I get involved in it.
Okay. Yeah, I just wondered, I know you can't comment on other attorneys, but I've known you a lot over the years, and I know that you've gone to court 5, 6, sometimes even 10 times for people. Yes. And I was just really surprised to hear that. Is that a major expense to you, or is that a major expense to a lot of attorneys? And why would an attorney either do that or not do that? I know these are just surmises because, it's not your practice, everyone's practice, but what are your thoughts?
Well, I build into my fee the idea that I'm going to do all this work, and I only get involved in a case with the mindset that I'm going to give it everything I have. And if I have to go 10 times and I have to go to trial, that's okay, because I want to see the right result. I don't mind if I have to take years to get the right result on a case, even if it is beyond what I anticipated the so-called cost to me would be as far as time is concerned.
That's really great.
Of course, I'm running a business, but I also am in this profession to try to make sure my clients get the best results possible, because I do believe in the justice system and doing my part in that system. I know it sounds a bit corny, I guess, maybe old-fashioned, but that's why I got into the business, and that's what keeps me going.
I know you don't know, but do you feel like most cases need 5, 6, 7, 10 trips to court in order for you to get a good outcome for the client? Or, if you didn't do that as much, if you limited it to 3, if you were just a lot less generous with that, do you think that you'd have nearly as good a results?
I developed a process over the long period of time that I've been doing these cases, and I find that if I ever try to shortcut the process that I've developed, 2 things can happen. A, I'm not going to get the best result, and B, I generally see a client getting upset, because I think clients are a lot more savvy than lawyers give them credit for, and they can tell when the lawyer is putting in the adequate time into the case. So if I ever had tried to shortcut my process, I just didn't find it to be a desirable result came from it. So I don't do that at all. I stick to the process. The process works. The process has been developed through thousands of cases that I've handled over decades. And, if it works, stick with it. And along the, in the process of developing the best way of handling these cases, you go through the trial and error of handling the matters. And sometimes I've tried things that just didn't quite work, so I cut them out. And sometimes and then I've adopted practices that I find work a majority of the time. So why not stick to those processes?
Yeah, no, it makes sense. Well, all right. So, going back to the story, what happened over the year plus that you worked on the case? What was the end result?
End result was we went to trial. The officer who arrested my client ended up being a very lackluster witness. I was able to get a ton of inconsistencies out during my cross-examination. And the prosecutor realized by the end of the trial that his witness had not done the best job. And so he offered to drop the DWI and allow my client to plead guilty to a lesser traffic offense, which my client was absolutely ecstatic about.
Yeah, that's really great. That's excellent. Out of morbid curiosity, what's the most times you've had to go to court on a case, or what's the most work you've had to put in?
That's a very good question. I don't know, maybe 15 court appearances over a couple of years. And by the way, these cases are supposed to be resolved within 60 days. So that gives you a good idea of what the time period the courts have in mind for these cases. But I don't adhere to it because I need to do a thorough job, and I can't do a thorough job for my clients in 60 days, generally speaking. The system's not designed to work that way. You're not going to get all the discovery that you need. You're not going to get the expert's report in that period of time. You're not going to be able to get involved in some serious negotiations with the prosecutor. And, it's tough to really get to know your client and the client's case in a truncated period of time. You need time to develop the case, to develop the defenses, and to develop a good rapport between lawyer and client.
Yeah, no, it makes sense. Well, excellent. People listening to the story that want to get help from you, where is the best place they can go to get that help? How do they find you?
Well, they can go to my website. They can simply look up Leckerman Law, Leckerman Law, and they'll find a couple of my websites. One is DUI-defenselaw.com, and the other is winning-DWI-defenses.com as well. And they can also reach me at 800-378-2110 or in New Jersey, 856-429-2323.
And just to reiterate, so you handle, what parts of New Jersey do you handle, and what parts of Pennsylvania do you handle?
Well, generally speaking, I've narrowed my practice to New Jersey. And so I'll take cases all over the state of New Jersey, but primarily I focus on southern New Jersey and central New Jersey. Okay,
so if someone chopped New Jersey in half, vertical wise, the bottom half you definitely service, and as you're getting up into the top half, you may or may not be able to help somebody. Yeah, if they're chopped in half horizontally, I would say generally speaking, my cases, they'll go up to like around Trenton area, so the capital and across the state. Excellent. Well, that's a great story.
This is the Secrets of Attorney Marketing podcast from Speakeasy Marketing. Discover how to enhance your reputation as an attorney and outmarket your competitors. Make sure you subscribe to the podcast and post a review.